Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we discuss a very important judgment for corporate India. It comes from the Calcutta High Court, and it says that the Calcutta High Court has held that a former director can't be compelled to represent a company in a money laundering prosecution after he has severed ties with that company. Very, very important for corporate India, because once you have left the company and you're summoned, of course it's not an easy, because court dates are frequent and it draws you into a battle that you would rather be not part of. And this was in a criminal revision petition filed by a former director of Disc Production and Media Limited, and a bench of Justice Ajoy Kumar Mukherjee ruled that the prosecution had no authority to decide on who should appear on behalf of a corporate accused. Very, very landmark judgment, something a lot of corporate India is happy about, and we need such judgments. I want to welcome two experts who can reflect on this more. I want to welcome Justice Sadhna Zadav, who's also now a senior advocate at Supreme Court and also a known arbitrator. Good to see you, ma'am, on Legally Speaking for the first time, and thank you for your time.
Hello. Yes.
I also have to welcome Neha Nagpal. She is founding partner of Erin Law Chambers and does a lot of work on the financial crime side. So this issue fairly falls into her ambit. Good to see you, Neha. Thank you for your time.
Thank you for having me, Tarun. It's always a pleasure.
So at the outset, Neha, if you could sort of reflect on this judgment for a bit, present your argument on what do you think, and because day in and day out, this is what you do up here for corporate India on financial crime matters, be it LOCs, be it fraud, issues of them being accounts being declared as fraud, and now this is also an important issue. Over to you for your opening comment.
So this judgment sees an interplay of Section 305 of the CRPC, which allows a company to be represented by a authorized representative. And that is a settled principle. That specifically deals with all IPC offenses and to some extent even the NI Act. Now, when it comes to the PMLA, again, that's a settled position that it's a special statute. It has two interesting provisions of law. One, which is Section 24, which is a reverse owners clause. We are as such not concerned with that for the present issue. Second is Section 70, which is strict liability on any person who was looking into the affairs of the company at the time of commission of the offense. Now, that means you can make that person liable and responsible and accused in his personal capacity. But if you are not making that accused in his personal capacity for A, B, C, X, Y, Z, good, bad reason, then you cannot say Mr. So and so is the only person who has to represent the company for an offense that took place 10 years ago. And in fact, 10 years ago, this gentleman ceased to be, or this lady ceased to be a director of the company. In this particular case, ED served the summons only on a particular director who had resigned prior to the ECIR being registered. The period of offense, he may have been a director, but the ECIR gets registered post. They are not, ED is not concerned with him in individual capacity, but they are now conflating the identity of the company and this individual to say only and only this gentleman will represent the company who has ceased, who was a director at the time of the commission of the offense. And Calcutta High Court very correctly holds that, look, he has ceased to be a director. Section 305 of the CRPC otherwise applies to the PMLA, save and except when there is a conflict. Section 70 and Section 305 have no conflict because they operate very differently. You are not making this gentleman accused in his personal capacity. You are saying because you were a director of the company in that period of time, represent the company. That doesn't work. And that doesn't work not only because of Section 305 read with Section 70 PMLA, but it doesn't work because are you holding him tomorrow when you come to a case of fast forward 10 years, trial has happened, you have to go convict the company. You will still be convicting the company. You are not convicting him in his personal place. You can't say that you will go to jail because you are the company. No. And it's settled law again that even for the company, all you can do is impose a fine. You can't send the company to jail, implying thereby you can't send the AR to jail. what has happened probably in this case is, I haven't read the complaint,
Yeah.
is that they have found no material rightly against this gentleman, but to try and implicate him, because you were a director in 2013, you have to appear for the company. That is what has happened, and that's a totally wrong reading of the provision of section 305 CRPC and section 70 PMLA. And Calcutta High Court has taken a very correct view. That's really the long and short of it all.
Thank you for that opening comment. Now we'll go to Justice Sadhna Zada for her opening comment. Ma'am, over to you.
I fully agree with her. See, there is every possibility. Because even I have not read the complaint, to be very frank. We are only going by the judgment which has come, right? In which all the facts of the case are not elaborately discussed. You people must have seen that. What do you say, counsel?
Yes, absolutely. Absolutely.
All the facts have not been disclosed. The details are not given. And then, see, earlier it was so. Now this director, he comes, and suppose in the course of trying the case or looking at the charge sheet, whatever the material before the court, in case they find some aspersion against him, could be, you never know. A third party may say, yes, he was also involved in it, right? So, could he be taken under 319 and you are asking him to represent the company? So, what if his involvement was there in those transactions or whatever accusations? First of all, I fully agree that the Calcutta High Court has taken a correct view that he can't be forced to, like, why should the prosecution choose him alone to represent the company? Why he alone, who was not presently concerned, and moreover, the period during which the accusations are made for? That period will be very important as to what was his role during that period. And that will have to be taken into consideration. We don't know the facts whether he was in service that time or what position he was holding. Has it been mentioned in the judgment? I don't think so.
It just simply says he was a director.
But director, but then you see in a company, there are different roles assigned, right? Maybe looking after the day-to-day affairs of the company, looking after only the marketing of the company. We don't know where exactly the water is logging. So how can you expect him to represent the company? And secondly, why was the notice served on him alone? That is the core issue. Like, you give up the present directors and you ask someone who was working with the company in the past. And the possibility can't be ruled out that someone comes up with new accusations and says that he has a vested interest. So whether he can speak against the company if he is representing and he really did not agree, suppose, with some decision. There could be certain decisions taken in which this person must not have agreed. Can he tell this against himself to the court or against the company? So the choice of the representative is totally wrong, even legally as well as ethically. What do you think?
Absolutely.
Because
Absolutely, ma'am.
Point very well taken, ma'am. I'll go to Advocate Neha Nagpal, taking your, in a sense, opening comment. See, the prosecution agency has not thought it fit to question this person or name him in the charge sheet. Do you think that also sort of gives no reason for the prosecution to call?
Absolutely. And Tarun, secondly, the prosecution cannot today choose just
right.
so and so will represent the company. There is a concept of internal management, doctrine of internal management, which allows the company to manage its affairs internally. Today, the company can decide whoever. It can decide literally the whether it has to be a director, whether it has to be a manager, whether it has to be the president or a clerk to represent the company. It's really nobody's business. As long as the company is appearing, Vakalatnama is entered, tomorrow they can decide which lawyer has to represent
Correct.
the company.
So that's a very fair point, Neha. See,
No, there is one more thing, Tarun. You see, if they want to choose a representative, the law requires that they have to pass a resolution to that effect.
Yeah.
Oh.
The first thing is the company will have to pass a resolution saying that this person will represent the company.
Okay.
Now, if that resolution also, they will have to give some explanation why they have chosen him.
Yeah.
And
Ma'am,
at present, he has got nothing to do with it.
Ma'am, I want to ask you one thing. Sorry to interrupt, and you can continue
Yeah.
on. See, in corporate India, we see individuals work in one company, then they go to Singapore. Some person
Yeah,
might go to
right,
UK.
right.
It's very common these days.
Common.
In
Yeah.
the upper echelons of the corporate India, there is a lot of movement even within countries.
Yes.
At such a time, to summon somebody, maybe highly inconvenient also, highly inconvenient also from the point, maybe highly inconvenient also from the point of view of if he's not required and he's summoned, it's a cost to time, it's a cost to money, it's a cost to, in a sense, his work where he's currently engaged. Do you think that the court has paid attention to all of this and hence this order?
Yes, of course. Oh, that is one aspect. And secondly, I would not directly say, but it looks like a malafide. You don't name this person as an accused, either in the complaint or the charge sheet. And then you call to represent him. It sounds as if maybe, I can't speak for the court as such, but maybe the court could see some hidden agenda behind it as to why a particular person is chosen. What is it that they want from this person? And secondly, what is missing in the judgment is whether his consent was taken to represent the company. See, that is another aspect.
So basically, if his consent is not taken and the prosecution is summoned him, which means
no, that is precisely, I'm telling you, when you are choosing someone to represent a company, a third party can't choose it. There has to be a proper resolution in place because he is going to speak on behalf of the company. And if the company doesn't want him to represent,
yes,
how could he be forced to? And secondly, if he has given consent or not, that is also missing. So the court must have sensed that there is some hidden agenda behind all this.
and this is actually, why we raised this also today, is that, see, there are so many prosecutions currently going on.
Correct.
It sends shivers down corporate India.
Correct.
You end up being in companies where things, their prosecution happens.
Yeah.
You're served for 2 years, 3 years. In your career of 30 years, you go on some other company. For the other promoter's fault, if at all he is in fault, you have to go to court again and again.
Correct.
Neha, could you weigh in on this?
No. So, see, there are two things. You break this down in two ways. One, does the check period or the period of offense, as we call it, trace back to the time that this person was a director?
That's
It
precisely
seems he
what I
was.
was saying. Yes.
If he was, then Section 70 may apply to him because the offense has occurred while he was a director. But for
Yes.
that, to prosecute him, you need to make him an accused in individual capacity as Mr. ABC, son of Mr. XYZ, resident of so and so. You cannot make the company look, whether the check period is 2013 to 2020 or 2020 to 2025, the company will be made an accused because it's in relation to the affairs of the company. Now, you very many times when summons are issued, they say company through director, but you can't choose a particular director. It is then the obligation of the company, as ma'am rightly mentioned, to pass a board resolution and say the board of directors authorizes Mr. ABC, because he could be the legal manager, he could be the GC, to represent the company in this matter, or he could be anybody. That is totally separate. But if you have now made this gentleman an accused, if you are coming after a particular gentleman and he was not a director in the check period, suppose the check period is 2020 to 2023, he resigned in 2015 or 2013, as the case may be, then you can't make him a accused even in his personal capacity, unless of course there's some other overwhelming material. Or you can't definitely make him serve him as a director of the company because he ceased to be a director. So till there is no role that can be ascribed to him, Even to meet the test of Section 70, you cannot make somebody an accused, much less direct that only he and only he will represent the company.
That's a very fair assessment that the prosecution cannot dictate who from the company will represent and pick and choose directors from 8 and 10 and 5 years ago and say there were 4 directors. This guy, I want this gentleman to be present in court. Uh, Ma'am, you've served as a judge of the Bombay High Court. The courts, do a stellar job sometimes, when, of course, agencies also,
Yeah.
when they are, or the prosecutions also in this sense, when they get overexcited sometimes about things, not realizing how much of a problem, for a man, in the end, even a director of a company is a man in a service job.
Correct.
He's not the owner. He's a
Owner.
professional for hire who's paid a
Yes.
salary. He goes.
Right.
So, culling anybody out of their current work to someone, unless, of course, there is some prima facie evidence against them. In this case, it was maybe not. Uh, do you think that courts here are doing a stellar job? I link it to investment in India because all these things, when the courts stand up, it is a thumbs up for invest in India because people know that courts will stand up for what is right in case there is injustice done.
Yeah, because see, the first thing that the court would take care is any prosecution is a fair prosecution and it doesn't get converted into persecution.
Very fair, sir.
Yeah.
Very fair.
So when you are seeing the papers, you are seeing it from a very neutral point of view, right? So when you are seeing as to whether the prosecution is fair or not, or as she rightly said, Ms. Neha rightly said, that just making him an accused, even naming him is not sufficient. You have to ascribe the role. And here, if he has not been named, the first thing that the court will ask, and it's a very fair question on the part of the court, as to what does the company have to say, whether the company was given a choice as to who should represent them. See, the company has got its own identity. And therefore, the liberty of the company cannot be taken away. And here, the courts really come down heavily upon the prosecution just to see that the rights of every individual and taking the company as an entity by itself. So their rights have to be protected. And that is precisely the reason why the High Court of Calcutta has come down heavily and said that, no, you can't do this. And this view should be upheld and should be considered by all the high courts. Because see, in some other, before some other forums, there could be some pressure. Because there are some forums where they feel that whatever the investigating agency is doing is always doing the right thing. Why? Because they are investigating fairly or they are a neutral body. But
I think the judges of this country, going by the comments they make, I don't know, they fairly understand whenever whatever is happening. Sometimes the order may be lenient, but the comments of the court many times give away what the judge is thinking.
Yeah. See, it is somewhere in your subconscious, you are imparting justice. So that need to impart justice or the urge to do so, it makes them, this comes naturally. Of course.
Point very taken. Ma'am, we want to go to our rounds of closing comment. Justice Ajoy Kumar Mukherjee, in this case.
Yes.
I think a stellar judgment and a stellar job done in this case by sending a message to the industry that stay invested in India. The courts will stand up for you.
Right.
Your closing comment for today's show.
So I feel that the court has taken a right view, and no company which has its own identity, entity, which you have to look at the company also as an entity and not allow the prosecution to take such overwhelming steps by forcing as to who should represent them. Because everything, it has to be reasonable. Reasonable means they have to assign some reason for it.
Basically, doctoring of reasonableness.
Yes, reasonableness has to be there. And here they have no reason nor cause to force this. If they could justify this, they have not assigned any reason as to why this particular person was chosen to represent.
Point very well taken. Thanks for that. And Advocate Neha Nekpal, your closing comment for this judgment by Justice Ajay Kumar Mukherjee.
So I totally second what ma'am said. You can't be in a position where today the prosecution starts dictating, or for that matter, even the court starts saying only so and so will appear.
Correct.
There is, if you've severed a legitimate relationship way before the ECIR is registered, if there is, you're not in the realm of an accused, and even if you are in the realm of an accused, you as an individual are totally separate from the company. It is settled first principles of law that the company is a separate legal entity. It has an identity of its own. To that extent, Article 14 can be invoked even by a company. So it has its own, rights in that manner of speaking. And of course, there are its own liabilities. So today to, insist is without any basis, without any cause, without any relevance. So I think this judgment has been upholding the legal principles, upholding the statutory principles, and also balances investigation qua prosecution.
Point very well taken. Indeed, a thumbs up for this judgment by Justice Ajay Kumar Mukherjee.
Yes.
In fact, it takes a judge, a certain kind of a judge, to understand. It's also empathy, and that's why we discussed today.
It's a couple of things, Tarun: empathy, realism, and economic concepts. Economic impact. And Justice Sikri was the first one to say that in 2017 in his judgment, that courts have to, it's time that in modern India, courts come to realize that there is an economic impact and a consequence, positively and or negatively, of every judgment.
Yes, that's what, in fact, that's why I do this series of the economic impact of court judgments now and then. I would like to thank Justice Sadhna Zadav, who's also senior advocate now and an arbitrator, Advocate Neha Nagpal, founder, partner of NM Law Chambers. Appreciate that you gave your time for such an important topic that sort of affects a large part of corporate India. Thank you so much for joining us.
Thank you.
Thank you.
Thank you for having us.
Thank you.